Well, assuming an employee's been injured and it is a work-related injury, what must he or she do to initiate a workers' comp claim? Can you kind of walk us through that process?
The very first thing you have to do, assuming you've got medical treatment and all that's under control, you want to make sure you're okay physically.
Mm-hmm.
But the very first thing a person has to do is give notice to their employer of the injury. If you can tell your supervisor right then, that's best.
Okay.
The statute actually requires written notice, but the courts have construed that to be constructive notice if you tell the supervisor. Still, it's always a good idea to have a friend be there when you tell them, or write it down on a piece of paper so you can document it, because some supervisors may forget about it or may not want to report it.
Mm-hmm.
But the very first thing you need to do is to give notice to your employer. Notice needs to occur when you realize you have a workers' compensation claim. For instance, you may have a condition, you might be picking up bricks at work all day long, and 3 months later, after your back's been sore, you go to the doctor and he says, well, you've got a bad back, and then 3 months later he says, well, your bad back's due to your picking up bricks all day long at work.
Mm-hmm.
When you know that it's due to work is when you have to give notice, and that was actually one of the changes in the statute a couple of months ago, is that there's a 2-year limit when you find out about when you get notice.
Is it the old when you know or should have known?
Pretty much, yes. That's the standard, and actually it's been defined even further to be when a physician tells you.
Okay.
A medical provider doesn't have to be an actual doctor, but a chiropractor,
okay,
physical therapist.
So 2 years from that date to give notice to the employer.
Essentially for a traumatic injury.
Okay.
Different standards for coal mining, if you contract occupational illnesses. But for traumatic injuries due to repetitive motion, it's a 2-year statute, yes.
Okay.